A heartbreaking case out of Louisiana. A mother accused of the unthinkable, beating her own baby to death. Her child, an innocent little boy, was just 8 months old. Now she sits behind bars charged with murder. I'll walk you through the details. For Law and Crime News, I'm Kennedi Walker. Before we get into this case, I want to tell you about something exciting at Law and Crime. We are launching a new channel called Scandal that is dedicated to exposing the dark side of fame, covering all the wild crimes in Hollywood, and diving into the disturbing rumors floating around celebrity circles. To stay up to date on all the latest celebrity scandals, click in the link in the description of this video and subscribe to Scandal today. All right, back to the story. A little boy will never get the chance to grow up. He'll never take his first steps, never go to kindergarten, never experience his first crush or his high school prom. His life was stolen from him before he even reached his first birthday. His name was Sterling Rogers, an innocent baby whose life came to an apparent violent end on March 17th. According to the Franklinton Police Department, officers were called to Riverside Medical Center on March 12th after an 8-month-old was brought in with disturbing injuries. The infant, later identified as Sterling, had both fresh and healing broken bones. Due to the severity of his injuries, he was airlifted to Children's Hospital in New Orleans. Doctors fought to keep him alive, but 5 days later, he succumbed to his injuries. He passed away. Now the investigation takes a grim turn. It's no longer about who hurt Sterling, but who allegedly killed him. According to police, they worked tirelessly, interviewing witnesses and suspects, and just 2 days later, they made an arrest. It was Sterling's own mother, 24-year-old Autumn Harper. Police say Harper was arrested after she allegedly voluntarily made a statement that implicated herself in her son's death. Franklinton Police Chief Justin Brown told WDSU that preliminary information from the infant's autopsy showed fractures in the ribs, arms, and legs. Sterling's skull was also fractured. The majority of those injuries were reportedly healing injuries. Police have not released crucial details like who brought Sterling to the hospital or if Harper has a history of abuse. It's also unknown where Sterling's father was when his injuries took place. Harper's mother also told the news outlet that her daughter allegedly admitted to the injuries, saying, quote, "She admitted to small things, like putting her hand over his mouth, maybe when he was crying." In an interview with Fox 8 News, police shared it appeared the 24-year-old struggled with her mental health. I did some digging into Harper's background, and here's what I found. On her social media, you'd probably never believe that she's accused of a crime as heinous as murdering her own son. Her Facebook page is filled with pictures of her and Sterling, along with posts documenting her pregnancy, seemingly proud and happy to be a mom. Her relationship status says she's engaged, but it's unclear to who. Harper claims to work as an assistant manager for a finance company. And in 2022, she was married to a man who is not Sterling's father. Her husband passed away shortly after their wedding. Now Harper's been booked into the Washington Parish Jail. She faces 1 count of first-degree murder for the death of her son, Sterling. In a statement, Franklinton Police Chief Justin Brown said, quote, "In his over 30 years in law enforcement, he's never experienced a case like this one," and says it is absolutely heartbreaking. The police chief also continued by stating this was a tragic event that will have a long-lasting effect on all involved. Our prayers go out to the family for the loss of this beautiful child. Joining me to talk more about this story is legal expert Safa Robinson. Safa, thank you so much for coming on today.
Thank you, Kennedy.
So let's just dive right in. Autumn Harper is charged with first-degree murder. What does that charge mean under Louisiana law, and how does it differ from second-degree murder?
Under Louisiana law, first-degree murder can be achieved by the intentional killing of another person or intentionally inflicting grave bodily harm on that person, and ultimately results in the death of an individual. Not only that, but specific to first-degree murder, there are a ton of other subsections that a person can be charged under. Of course, intent is the mentally culpable state or the mental component that is required. But specifically under their first-degree murder statute, there is a caveat where an individual can be charged under that statute if there's cruelty to juveniles is one factor. Not only that, but if an individual is less than the age of 12, that would fall under first-degree murder in the state of Louisiana. They do have a second-degree murder statute that's very similar to their first-degree murders. However, First degree murder has more of a catch-all in the state of Louisiana. With second degree murder, there is the intent factor, the intent to kill or the intent to cause grave bodily harm, and it ultimately results in that death. And there's also the capacity to charge an individual, or there's also the ability to charge an individual under that statute with respect to juveniles, but there's no mention in that second degree murder statute of someone under the age of 12.
Given your the facts of this case and with your just legal opinion, how likely is it that prosecutors will seek the death penalty in this case?
Louisiana is a pretty tough state. I think if there's any state that I never want to get in trouble in, it is Louisiana. It's highly likely that they could, seek the death penalty in this case. I think it's going to depend on how the factors come out. If there are any significant aggravating factors with respect to the death of this child, then of course the prosecution is going to want to seek the death penalty. If there's some mitigating factors, so say we find out that mom, maybe had postpartum or something of that nature, then the prosecution might forego the death penalty phase or requesting the death penalty and just opt for a sentence of life in prison.
I want to thank Morgan & Morgan for sponsoring today's Law and Crime YouTube takeover. If you've seen our videos, you know Morgan & Morgan is a proud sponsor of Law and Crime and that our content proves the world isn't always safe. When you're hurt, it can be confusing, it can be scary, and you don't really know where to turn. Well, Morgan & Morgan, America's largest injury firm, can help. They're the largest injury firm because they win a lot. Morgan & Morgan has recently received verdicts of $12.2 million in Florida, $26.2 million in Philadelphia, and $6.8 million in New York. All of these, by the way, were significantly higher than the highest insurance offer. Also, there's zero upfront fee. You only pay them if you win. And what does the prosecution have to prove for a first-degree murder conviction?
In order for the prosecution to prove first degree murder, they have to prove that this defendant intended to kill this individual, intended to kill this 8-month-old baby, or that she intended to cause grave bodily harm to this child, which ultimately resulted in the death. Not only that, but they also have to, if they're going under the subsection where if you intentionally cause the death of someone under the age of 12, then with that, they would also have to prove that this child or the child in question was under the age of 12. They'd have to prove that beyond a reasonable doubt. They can prove that by having the father of the child testify if he is cooperative. Not only that, one of the things that the prosecutors do is they have the power to subpoena for medical records and birth certificates. So another option to do that would be to subpoena the child's birth certificate and move it into evidence to prove that the child is, of course, less than 12 years old.
Since Harper reportedly made a voluntary inculpatory statement, how does that necessarily impact the case? And could her defense challenge it in court?
Certainly. So, one of the things that the defense is always going to try to do is argue that any statements that she made to law enforcement prior to being read any Miranda rights, and I don't know the facts here, but any statements made prior to Miranda, that those statements should be thrown out or they should be inadmissible. The defense is always going to challenge these things. I don't know specifically what the statements were, but if it's something that could be damaging to her, if there's an admission on her behalf, then the defense is certainly going to want to keep that out. The prosecutors, of course, going to want to use that, and we call that an opposing party statement under the law or in the rules of evidence. So it's going to depend on what ultimately happens at a hearing in this case, if that does take place.
Does Louisiana allow insanity defenses? And could her legal team argue something like similar to what you mentioned earlier, potentially postpartum or mental illness?
Absolutely. So, under the state of Louisiana, it does allow for an insanity defense. If at any point in time the person's culpable mental state or their mental capacity is in question, then there is the possibility to argue insanity. What happens in a case like that, though, oftentimes is that the prosecution of the case will be suspended until that person gains competency or capacity. If the person is deemed competent and they make it through the trial, and the defense argument during that trial is that she was under some psychotic break or something of that sort, then the likelihood is that they'd be calling in expert witnesses to discuss, yes, post-traumatic stress disorder, any mental health diagnosis, or I don't know what the facts are, but there was any battered woman syndrome that may have impacted, abuse and her possible decision to abuse this child, or in whatever manner it happened. That is a possibility, yes.
And can you just dive a little bit more into that? I don't have the statistics pulled in front of me, but I know a lot of women deal with postpartum. But in the same, breath, in the same statement, while a lot of women deal with postpartum, it's not like a lot of women are accused of, killing their babies. Can we just talk more about that?
So, as a society, we're seeing a significant uptick in postpartum depression and things of that nature. And so, it's not uncommon to see this, although most women, I would argue, don't murder their children as a result of that. But I think that it's taken on a case by case basis as we assess, the individual specifically, what's going on in their life, what ultimately happened or triggered this act to occur. I don't think any of it is going to excuse the fact that we have a deceased child here. Certainly could play into any mitigating factors as the case proceeds, and there's always a possibility that an individual could accept some sort of plea, or there will be plea negotiations with respect to this case so that they can forego trial. It's just going to depend. But as the world continues to change and we start to see this more and more lately, I think that these arguments are going to come more to the forefront of cases where we do see homicides against children, specifically at the hands of their mothers.
Well, what role will Sterling's autopsy report and medical records play in the trial?
Those are going to be crucial because one of the things that the prosecution is going to try to prove is that she intended to do this. And one of the things that prosecutors do is they will put on the medical examiner to discuss the injuries that were sustained by the child. If the injuries are consistent with something that was accidental, maybe a fall or something like that from a small confined area, or is it consistent with something like blunt force trauma, and what type of trauma was sustained to a specific part of the body. And at what level of force was used to sustain those injuries is another thing that's going to factor into what the autopsy is going to show, or what the medical examiner is going to say. And fortunately, they're able to determine those things with these autopsy reports. I believe in this case, there, when the child was ultimately taken to the medical examiner's office, there was an indication that he had some healing bones, which showed that there were injuries prior that were in the process of healing, but also some fresh injuries that he sustained. That's going to go to the intention of what occurred, or what the prosecution is going to argue as the intentional act that occurred that ultimately led to the murder of the child.
If convicted, what are Harper's possible sentencing options, and what factors could determine whether she gets life or the death penalty?
So the sentencing factors under the first degree murder statute would be, or the sentencing options, I should say, are that if she's convicted, she could face the death penalty if the prosecution seeks the death penalty. Not only that, but she also faces spending the rest of her life in prison, which is also a possibility. So life or the death penalty. Under the second degree murder statute, if the prosecution were to seek it, she would be spending the rest of her life in prison. And a number of factors will go into how an individual is sentenced. There are sentencing guidelines that the statute will call for with respect to the murder charges. So again, that possibility of life, but if there's an application made for the death penalty, that can be done. But there's also mitigation that can take place. The age of this individual, the dynamic between this individual and her family life, any possible abuse, any, what if anything, occurred, or even the fact that, or possible fact that she had postpartum depression at the time. Those things could be what we call mitigating factors, which would essentially lessen the sentence. They ultimately humanize her to say, what, yes, this incident occurred, but these were the factors that contributed to that. And as a result of that, instead of maybe seeking the death penalty, we're going to go along with life. Or there's always the alternative where there can be an agreed upon plea offer or sentence of manslaughter. And ultimately, she could plead guilty to that and even lessen the life sentence on the back end.
How does Louisiana handle child abuse related homicides? And are there special considerations for cases involving infants?
It seems to me that with respect to infants and juveniles and things of that nature, those are more reserved for the first degree murder statute, which I believe she was charged with here. So Louisiana takes it a lot more serious when the individual that's deceased is a child as opposed to another adult, and that youth or that juvenile or that less than 12 factor is a special circumstance that would allow for the prosecution to charge under that first degree murder statute. So those are the special provisions and treatments that children and juveniles get in the state of Louisiana if ultimately they are the victim of a homicide.
Now, despite her alleged statement, if there were no eyewitnesses, how does the prosecution prove that Harper was the one who fatally injured Sterling?
What the prosecution is going to want to do is establish a timeline of events and what happened, how the police ultimately got called to the home or to the hospital. I think this may have been in a situation where the child went to the hospital and the police responded there. The injuries that were sustained, at what time the child was brought in, who was the child brought in with, if it was mom, what did she say to medical providers at that point in time on behalf of the child? Is there a history? All of those, and is there a history with mom and suspected abuse, any CPS records? The prosecution is going to want to obtain all of those things. They're going to want to establish a timeline that mom would have had the child. Say they lived in an apartment building and there's video cameras. They show her leaving with the child at a certain time to go to the hospital. She's the only one there at home. Dad may have been somewhere else. Other family members may have been other places. So they will try to prove beyond a reasonable doubt that she was the only person with the child at a specific point in time, that during that time, these injuries were sustained. No one saw the child injured prior to this, but ultimately after her being with the child on her own, he sustained these injuries, and ultimately those injuries directly led to the death of this child.
Well, what role do medical experts play in a case like this? Could they potentially testify about whether Sterling's injuries could have been accidental?
Absolutely. So, and this happens quite often, is there may be a battle of the experts. You'll have the medical examiner who will be qualified as an expert to say this child died in this manner with these injuries and in this way, and I've ruled this a homicide because of X, Y, Z. And then the defense may get another expert that says, I disagree with that. This could be, something more consistent with a fall. There may be an argument. Maybe the child was at a playground or in someone else's care and maybe fell down the stairs accidentally. So we don't know, but there could be a battle of the experts here, negating what the other is saying, and the jury will ultimately have to decide who they're going to give more credibility to in terms of the proof on the case.
Could prosecutors argue premeditation based on Sterling's alleged past injuries, or would this be considered a single act of violence?
They can certainly allege it. Just because you can allege it doesn't mean that that's going to be your strongest point. I think that one of the things often happens, at least here in New York, is that prosecutors try to argue that there's a pattern of behavior, or a pattern of abuse, that ultimately made it so that this ultimately occurred. But that's not always allowed in court. We don't ever want to have proof, and judges will usually rule against proof that shows that a person acted with propensity or in conformity with a certain act prior. So it could come in, it could not come in. It's ultimately going to be up to the judge in this case. The prosecution is going to certainly want it in, and they will most definitely, if they can, argue premeditated based on those factors if they exist.
What are some defense strategies her lawyers may use to avoid a conviction? If you were her defense attorney, what would you do?
Well, the first things first is we're going to want to know, is she competent to stand trial? That's the first things first here. Can she aid in her defense? Can she participate in her defense if we were ultimately to end up at trial on this case? Then we go to, what occurred at the time. Is she the one that was with the child at that point in time? Did dad have access? Could somebody else have injured this child? In other words, point the finger somewhere else. That's certainly a possibility. If she's not the only caregiver for the child, then there's going to be an argument made that someone else is responsible for the injuries of the child. If there's any domestic violence or abuse between mom and dad, there's certainly going to be an argument made that father participated in abuse, and if he abused mom, then he likely abused the child. That could be an argument that's also made. If the proof is beyond a reasonable doubt or fairly certain that she was the one that ultimately caused the injuries of this child, Then we say, okay, well, what was going on at that point in time? Were you under some sort of postpartum? Then we may want to get an expert that will testify to how that could have impacted her at the time that this occurred. So there's definitely some defenses here. It's just going to depend on what route they decide to take.
And I know earlier in our conversation you mentioned that the defense might try to throw out her alleged confession to police. But is there any other ways that the defense may try to discredit the prosecution's evidence?
Of course, one of the most important things is credibility. With respect to credibility, one of the important things is that law enforcement, they're going to argue the credibility of the law enforcement officers that were involved. They may not be credible, or they may have done something illegal, or they may have coerced this individual to give a false statement, and that ultimately is how we got the confession. So they could make that argument and show that, in some way, shape, or form she was coerced. That's one way to attack it. But also, and just plainly stated, the argument is that law enforcement did something illegal, and as a result of that illegal activity, certain things should be suppressed from the trial if it ultimately makes it there, including this confession.
If Harper does plead guilty, could she avoid a trial and negotiate a lesser sentence, or is a plea deal unlikely in a case like this given the accusations?
There are often plea deals in cases like this. These cases are very sensitive in nature. It re-victimizes the family, or any surviving family members could re-victimize dad. And nobody wants to sit on a jury and where you have to look at photos of a child that's been beaten to death. So it's very sensitive. It's very much something that often can lead to a resolution short of trial. The prosecution can say, hey, we don't want to do a trial on this. We don't want to re-victimize the family. We don't want to put anybody through a 2-week trial. Have her plead to manslaughter. Whatever the sentence range for the manslaughter is, we'll give it to her in order to avoid going further. So that is certainly a possibility. They could say plead guilty to second-degree murder and you'll spend life and we won't seek the death penalty. That is also an offer, a possibility here as well. If she does plead guilty prior to trial, then she will not have a trial. The judge will sentence her based on an agreed upon sentence between all parties, and that will be it.
And you just talked a little bit about, the jury in this case, if it does go to trial. What challenges do prosecutors and defense attorneys face in jury selection for a case involving the violent death of a baby?
There are some extreme difficulties in getting juries on cases like this because this is such a sensitive topic, because it's a child. Picking a jury on this case is going to take days. A lot of times, especially during the voir dire process where we question jurors, people who have been victims of violence, victims of, abuse, victims of homicides through a family member, those individuals it happens quite often, and so it makes it more difficult for them to want to sit on a jury. A lot of times, even if someone in the potential jury pool has not experienced that direct cause of, homicides and things of that nature, they may sympathize with the idea of someone else saying, yes, this happened to me and I can't sit on the jury. And then they say, well, yeah, I would tend to agree with that. So I don't think this is a good fit for me either. A lot of people don't want to sit on juries. They don't want to sit on a trial like this because of the sensitivity in nature and to have to see those things. So it will be very difficult.
All right. Well, we will be following this story closely. Safa, thank you so much for coming on today.
Thanks for having me.
Autumn Harper is currently being held without bond. For Law and Crime, I'm Kennedi Walker.